Hello, I'm Rick Carmona from the Carmona Law Firm, and welcome to our beautiful garden here in Rome, Italy, where we are spending a couple of days making memories with our families. But we also want to share some frequently asked questions with you, and hopefully, we can help you answer how our ID legacy planning can help you and your family. So, the question I want to answer today is, what if I pass away without a will? Well, if you pass away with no will in place, state law fills in the gaps for you and dictates who receives your assets after you pass away. This is called intestacy. Florida law follows what you might expect the average person to choose. A surviving spouse is the primary heir, and then children. If there is no living spouse or children, then your assets would first be passed to your parents and then ultimately to your siblings, nieces, and nephews until someone is available to receive your estate. But this can become really tricky and complicated if you have a blended family or either you or your surviving spouse have children from a different relationship, because the numbers do get a little tricky. And don't just go out flat out 100% or in equal shares. We just had a case when someone died intestate. Our client, the decedent's second spouse, was limited to receiving only 50% of the assets because the decedent had children from a prior relationship, even though the children had not spoken to that parent in over 40 years. So even though Florida and state law does fill in the gaps to make sure the people who are close to you receive your estate, it might be different from what you would want. And it also doesn't clarify who's in charge of the assets left to a minor or an incapacitated beneficiary. So a judge may appoint someone you don't want, and it ultimately costs your estate and loved ones a lot of money. We know of a person who this happened to. Both parents died without a will, and the child, then 13, received close to $500,000. Since there was not a will and no parents left alive, the child was moved away from her home to live with a relative in another state, far away from friends, other family, and a community that had cared for the child for many years and through the tragedy. The court appointed a corporate trustee to watch over the money, who charged 1 to 200 per hour every time they touched a file. Also, when the child wanted money to go to a private school that would foster the child's love of music, the corporate trustee would deny the payment because it was not in the best financial interest of the trust, claiming that the child lived in an A-rated school district anyway, even though the district did not have a music program. The corporate trustee was only there to protect the money. Ultimately, the child hired a lawyer at age 16, paid for by the trust, by the way, and asked the court to emancipate them and had full access to several $100,000 at age 16. How long do you think that money lasted? Not long, unless we heard the child had dropped out of high school. So state law is really just following the family tree, but really doesn't do a whole lot more than that to make sure that those who receive your estate receive it in a way that you would want, and maybe specific ages along the way that you would want. So if you die without a will, state law fills in the gaps for you, but you can't rely on that plan. Even then, it's really important you make sure that you follow how the plan is laid out in writing, so we're not having to rely on state law for you. That's what ID legacy planning does. We help you figure out the plan that fits your family and your needs. So please click the link below to schedule an appointment, and please be sure to like and subscribe to the page so you can stay up to date on ID legacy planning information. Arrivederci for now from Rome. We'll see you next time.